Hi, Amy Pittman with Pittman Law Office, and I wanted to go over some commonly asked questions that we receive when we have consultations. Do I have to update my estate plan if I move to Florida from another estate? Yes, usually you're going to need to update what we call your incapacity documents, which is your power of attorney, healthcare surrogate. It may be called something different in the state you came from, but those are going to be very state regulated. So the way they turn on, even how they're signed, certain language has to be in our power of attorney. So we definitely tell people that you could just automatically assume that your documents from your other state, from power of attorney, healthcare, is going to be updated. Now, as far as a last will and testament, it depends. You really need to have an attorney look at it to determine if it's still going to work in Florida should you have a probate. Revocable trusts get amended. It needs to say that it's governed by the laws of the state of Florida or whatever state is your primary residence. So yes, it's worth the consultation with an attorney in the state you're a resident in to make sure that your estate plan is current to the state as well as to your situation, which a lot of times that's what happens is things have changed since the last time you've done your estate plan. Another commonly asked question is, do I need a trust? Well, it's going to really depend on your situation. There are some clients who have a trust just because they don't want their house to go through probate. But there are other times where we have beneficiaries that don't get along. Maybe it's a blended family, so we need to create a trust to get several people to be in charge as trustee. If you have a beneficiary that's on governmental assistance, then we're going to tell you to do a revocable trust. Also, if you have more than one piece of real estate, especially if that second real estate is in another state. So definitely reasons to have a trust. Not everybody needs a trust. So have a consultation with the attorney. In our firm, we send you an intake ahead of time so that you can give to us. So we have an idea of the family dynamics as well as the assets and type of assets, not necessarily the value of the assets, but the type of assets also determine sometimes if you need a revocable living trust. So it's definitely worth a free consultation. And the other commonly asked question is, how do I avoid probate? So that really depends. I mean, they're going to have assets to go through probate when the asset is in a deceased person's name alone. So if I have bank accounts, investment accounts, and I don't own real estate, and I can go into those banks or financial institutions and name a beneficiary, then I've avoided probate, because probate doesn't get involved for those assets that have direct beneficiaries, whether it's called pay on death, transfer on death. And then also if I have an IRA or some other kind of retirement account or life insurance, annuities, those type of products also allow me to name beneficiaries. So by naming a beneficiary, now this would be individuals or charities, that's going to bypass probate. If you name the estate of, so if I said the estate of Amy Pittman was my beneficiary of my 401k, that's going to go to probate. So these are commonly asked questions. We have no problem answering them. We just want to make sure that you understand that everybody's estate plan is different. So definitely feel free to call and schedule a complimentary consultations. One of the attorneys here, we'd love to sit down and talk to you about your estate plan. Have a great one.